I have been dealing with the decision cited by them. The next decision, my lord, is 2010 9 Supreme Court cases 157. That is the Greater Mohali area development.
So 2009?
2010 9 Supreme Court cases 157.
2000.
This has been cited on behalf of KIT. Their contention had been that
2010.
2010
9
9 SCC 157. This is Greater Mohali Area Development Authority. Well, this has been cited on behalf of KIT for the purpose of, in support of their contention that they had no knowledge of this cabinet decision by which this particular property came to my client. And they said that the order does not become effective unless it is published and communicated for that proposition. Well, I submit to your lordship, my lord, this is an absurd proposition. My lord, proposition is not absurd. It is totally inapplicable to the facts of our case. How can KIT say that they had no knowledge or notice of it, of the cabinet decision, when, my lord, the KIT's letters are there on record? I will just refer your lordship, my lord, to the page number. Your lordship will kindly look into them. All KIT letter, accepting the money, accepting the rent, accepting the ground rent, sanctioning the plan, accepting the plan which has been sanctioned. My lord, I just give your lordship, kindly come to page 69 of this compendium. I shall just indicate to your lordship the KIT letters. And then I shall submit to your lordship what application can this particular judgment have in the facts of our case. 69, 70, 71, the letters one after the other. Kindly come to page 69. In 2004, on the 8th of September, this letter had been written. And this is, they are saying that no objection certificate for commercial use of leasehold land at Uttaranga. Addressed to the officer on special duty, Kolkata Improvement Trust, by my lord, the Chief Inspector, NBSTC, Liaison Officer, Transport Department, Government of West Bengal. And there your lordship will please to see, they are writing that if your lordship sees this, I am directed to draw your attention to the related date so and so. NBSTC is the owner lessee of the plot of land of KIT, earlier known as CIT, at the crossing of the bypass, etc., to exploit the said land on commercial basis, for which it was decided by the government. We note this, for which it was decided by the government that NBSTC will pay rupees 2 crores to CIT for the issue of written consent in terms of clause so and so of the lease agreement. In fact, NBSTC is not in a position to pay the said amount to CIT due to its financial hardship. It is also known that a building plan on this score is under process by KMC, where such written consent of KIT is required. It is also stated here that unless the said building plan is sanctioned, NBSTC could not raise funds to meet its liabilities. On this context, I am directed to undertake before you that NBSTC will pay 2 crores to KIT within 60 days, etc. from the sanction of the building plan. Then, my lord, page 70, see, my lord, the officer of special duty of KIT is writing on 18th November 2004 at page 70. Addressed to the Joint Secretary, the Government of West Bengal Transport Department. In reference to a letter dated so and so, with a commitment to pay rupees 2 crores to KIT within 60 days and take up sanction the building plan for commercial utilization of the leased land at the junction of so and so. then NOC on the following terms and conditions. That no objection certificate would be issued to NBSCC for commercial utilization of the land leased out by KIT to NBSCC to facilitate sanction of the building plan by KMC as the block of land in the junction of Satyenbur, Sharoni and EM bypass in KIT schedule number so and so.
So the officer on special duty
Yes.
is writing this letter on behalf of KIT.
On behalf of KIT to the Joint Secretary Government of West Bengal. So, my lord, Government of West Bengal is being written by KIT saying that in respect of this land, 2 crores of rupees is to be paid, and my lord, they are fully aware of it. Then, my lord, kindly come to the next letter. This is also KIT's letter. Here again, my lord, kindly see that I am enclosing the last sentence. The first paragraph is enclosing 6 copies of building plans for the proposed building. I am enclosing 3 sets of approved building plans comprised of three numbers each of architectural and structural drawing. The name of my client would be there on the plan because the plan had been given by my client. So, my lord, they had full knowledge of that. Then, my lord, kindly come to page 72. Again, my lord, the letter is being written to the estate manager of KIT by the Chief Inspector in BSTC. It's very important. The subject premises was leased out to NBSTC by KIT for 99 years at a fixed rent of so and so per annum by the lessee in NBSTC to the lessor. Since execution of the lease, the ground rent was not paid by NBSTC. So, since the execution of the lease, that was it, the old lease that has been, the lease rent was not paid. Now, I am forwarding here with a demand draft of rupees 1,31,890 drawn in favor of Kolkata Improvement Trust on account of the said ground rent for the period from 12/10/1990 to 12/10/2007 for 18 years. The draft has been prepared through MA Construction and Trading, who has been engaged by NBSCC to develop the said land. And this is accompanied by the draft, which is mirrored at page 73. And they have accepted, encashed. So for 18 years, lease period, and now they are saying that we didn't have a notice, and therefore this is not complete. Kindly, my lord, come to the next page, page 74. Again, my lord, the estate manager of KIT is being addressed. A letter by NBSCC Calcutta. Recording that 18 years ground rent had been paid, and further rupees 5,93,000 for 81 years may kindly be acknowledged. And this also is by my client, my lord, at page 75. And kindly note that these bank drafts at page 73 kindly say MA Construction. Name is also written on the bank draft. So, therefore, this particular decision, nobody contests the decision themselves. But the point is this: to what extent it can be applied in the facts of this case. The facts are glaring facts. All parties are involved. NBSTC, first is state government, then NBSTC, then Calcutta Municipal Corporation, then KIT. All of them are involved and all of them are fully conscious and aware of the fact as to what is happening in respect of this problem. So, this particular judgment is not applicable to the facts of our case. Then, my lord, 2022 SCC Online Calcutta, Wall Rubber case, this is a Calcutta decision, has been cited. Wall Rubber Industries, this is Amit Chand Mitra. 2022 FCC Online Calcutta 2031. Well, this judgment, in my very respectful submission, is wholly in my client's favor. This judgment has been, my lord, I had the occasion to appear in this matter, and there, my lord, your lordship will be pleased to see that these judgments which I have cited before your lordship namely, my lord, that those two judgments have been cited, considered, and relied upon. Anthony versus Casey, it took the Supreme Court cases which I cited before Lordship, I think 2002, 2000, volume 6, Supreme Court case 394. Kindly may not come to para 18. This is wholly in our favor. I don't know why in support of which proposition it has been cited. But this is again in this is in support of my submission that even before the registration of the lease deed, which has taken place in our case, there was an unregistered lease deed in pursuance of which this particular property was given to my client. They were in possession, admittedly. They had not proceeded on the basis of this. A monthly tenancy was created. The right was there of my client, which my lord fructified into a registered leaseholder. After my lord, this was kindly come to para 18. This judgment which I cited yesterday, that is there referred to, Antony Casey. Then my lord, kindly come to the, after considering this extenso, my lord, it has been quoted. And in para 30, para 30, 30, 31. This really, my lord, naturally, my lord, Calcutta High Court could not deviate it from, my lord, the judgment of the Supreme Court. And I cited, my lord, these two decisions on yesterday. And two decisions, my lord, they were, one is, my lord, this judgment of KC Ittu, and the other was the Park Street decision, my lord, going from Calcutta, the Supreme Court decision, which is which I showed to your lordship, reported in 2016. Yeah, 2000. Yes. Park Street Properties was Deepak Singh, 2016, 9 Supreme Court cases, page 268. I cited yesterday these two decisions. Case it has been followed, and my lord, in para 30 and 31, what I had been submitting, my lord, had been again confirmed, which says that even though an unregistered document cannot be taken advantage of for the purpose of establishing title to the property, but then again, if it is an unregistered agreement in pursuance of which, my lord, the parties have acted, namely taking possession, paying rent, making construction, whatever it is, then, my lord, that particular document cannot be ignored. And it says that that document can be relied upon for the purpose of establishing a right in the property. So this judgment, my lord, in my respectful submission, does not help my learned friend, but my lord, this is in support of what I have submitted, and my lord, following the two judgments which I have referred to. Yes. দেখো তো পার্ক স্ট্রিট প্রপার্টিটা রেফার্ড হয়েছে এর মধ্যে। Lordship, will kindly give me 1 second. Para 18 is KC too, but I think Park Street property also I cited. The paragraph to bottom. Para 30. In fact, my lord, your lordship sees that in para 37, that and the
Is it
second
2016 9 SCC 268?
yes, that I
Paragraph 10, 19, and 17.
yes, my lord, this had been cited yesterday by me, and that had been relied upon also. So, my lord, this is confirming the proposition that I have, my lord, making before your lordship on this subject. So, this is the next decision which has been cited. Then, my lord, here তোমরা কি মহিন্দর সিং বিল সাইড করেছিলে? কোনো প্যারাগ্রাফ রিলাই করেছিলে? আমার এখানে লেখা রয়েছে মহিন্দর সিং বিল, ওরা কি রিলাই করছে?
জেন প্লাস্টিক্স, এটা এয়ার 2002।
I see. Well, the next judgment relied upon is AIR 2002 Supreme Court, page 206.
216.
Sorry, 216, not 206, 216. This is been wrong. AIR 2002 Supreme Court, page 216. Was titled is State of Bihar versus Jain Plastics. This has been relied upon by Mr. Mukherjee on behalf of the state of West Bengal. Well, here, this judgment, my lord, if your lordship kindly comes to paragraph 7, a very short judgment of 2 pages. Your lordship has got it.
Yes, sir.
Para 7.
Contractual transaction cannot be dealt
Yes.
under Article 296.
My lord, this is, I mean, nobody will contest this proposition. And in fact, my lord, your lordship will please to remember the decision which I cited of associated engineering. There, my lord, the court has held that even money claim can be, your lordship is pleased to see yesterday, that money claim also be granted into an article in a writ petition, provided, my lord, there is no
2004 3 SCC 553.
This is, my lord, therefore, my lord, there cannot be any absolute proposition that in a 226 application, money award cannot be made. If the court finds that on the basis of whatever is there on record, there is no question of, my lord, leading evidence with regard to disputed question of fact, and the court is able to adjudicate the disputes between the parties on the basis of the affidavit, well, that particular judgment said that there is no reason as to why, even in writ proceedings, a money award cannot be given. Your lordship will please recall, I placed this.
So your basic contention was to be on Article 14 of the Constitution, apart from contractual violation.
Absolutely. My submission is this, that my entire cause of action in all the 3 writ petitions is, my lord, arbitrary, unreasonable, and totally, what should he say, illogical decision taken by them, no, without any reason. One particular challenge has been made that one authority is telling the other authority, the Calcutta Municipal Corporation, don't issue the plan. Don't sanction the plan. I have challenged that. The second one authority is telling the other authority, do not give the permission. I have challenged that. I said, these are without any reason. Why? Why is it? You have given me a particular property. You have asked me to develop the particular property. I have given a sanction for a plan for sanction. There is no reason as to why you have not given any reason as to why the plan should not be sanctioned. And you are saying plan should not be sanctioned. I have come before the court. And third one is this, when you finally said that I cancel that, the board of directors have decided to cancel it. What reason? Why? Just like that, a land which has been given to a party on the basis of a registered document. On the basis of registered document, money has been paid. 13 crores of rupees he has paid. He had, my lord, started, my lord, doing the foundation work in the ground. And you suddenly one fine morning you wake up and say the board of directors has decided not to you not to proceed with it. Therefore, I am cancelling it. This is a third petition. All of them, my lord, are complaining of the arbitrary action. I said that state, even in contractual field, you cannot act in an arbitrary manner. This is what Mr. P.N. Bhagavati said in International Airport Authority. And throughout, my lord, this is the my lord, on this issue, since I am on this, lordship will take, my lord, a very recent decision of this of the Supreme Court. Lordship will please to take this. This is a judgment which has been reported in. I shall just give you, lordship, the reference. Now the law has undergone a serious change. And my lord, I submit to your lordship that in this regard, India is more advanced than both America and UK. The courts in India say that when the government is in any activity concerning a citizen, then the government cannot act in an arbitrary and unreasonable fashion when dealing with a citizen, because the government has the full power. Therefore, you are not to utilize the power in an arbitrary and unreasonable way. So wherever there is unreasonableness, the court says it is to be liable to be struck down. My lord, in the judgment of International Airport Authority, if I remember, my memory is not as sharp as it used to be at one point of time. My lord, in International Airport Authority, that paragraph 10, আমাকে দাও না, 1979 Supreme Court. My lord, there, that famous passage quoted from a judgment of Justice Frankfurter of America. He says P.N. Bhagwati had quoted that paragraph. This is, my lord, a paragraph from a case by the name of Vittorelli versus Satan. And that paragraph has been quoted. And it says, he who takes the procedural sword must perish with the sword. This is a very picturesque statement which has been made by Justice Frankfurter of America. And that had been quoted. তুমি নিয়ে এসো না এটা আছে, তুমি এখান থেকে বার করো, আমি তোমার প্যারাগ্রাফ বলছি, প্যারাগ্রাফ 10 দেখো তুমি। And I think, if I remember correctly, this is the sentence: he who takes the procedural sword must perish with the sword. So far as the government is concerned, it cannot act arbitrarily in any manner. Your lordship will please to take, my lord, on this recent decision, my lord, is 2022 16 Supreme Court cases. Page 2022 16 Supreme Court cases, page 527. And give it. Two 2013 Supreme Court case আছে? Lordship, can you give me 1 second? 2020 13 Supreme Court case বার করো। এখানে নেই, দেখতে পাচ্ছি। Yes, well, I've got it. দেখো তো 2020 13 সুপ্রিম কোর্ট কেস আছে কিনা, এটা তুমি কোনটা পেয়েছো?
Maharashtra chase
Yes, well, I was right. This is what it says. এটা কোনটা পেয়েছো?
Maharashtra chase
ওটা না, ও পরে। I was just quoting from, my lord, International Airport Authority. If I may just place this paragraph. This is just P.N. Bhagwati's judgment. Now, there can be no doubt that what para 1 of the notice prescribed was a condition of eligibility which was required to be satisfied by every person submitting tender. The condition of eligibility was that the person, etc. I am not troubling your lordship. This was the standard or norm of eligibility laid down by respondent number 1. And since the respondent number 4 did not satisfy the standard or norm, it was not competent to respondent number 1 to entertain the tender of respondent number 4. Then, my lord, it is well settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes its action to be judged, and it must scrupulously observe those standards on the pain of invalidation of an act in violation of them. The rule was enunciated by Mr. Chase Frankfurter, this is in Vitterelli versus Seton, where the learned judge said, then quote, an executive agency must be rigorously held to the standards by which it professes its action to be judged. If in a contract, certain, my lord, procedure has been laid down, certain, my lord, formula has been laid down, you are strictly to adhere to that. Accordingly, if dismissal from employment, it was a case of dismissal from employment, is based on a defined procedure, even though generous beyond the requirements that bind such agency, that procedure must be scrupulously observed. This judicially evolved rule of administrative law is now firmly established, and if I may add, rightly so. Then he says, he that takes the procedural sword shall perish with the sword. Well, this is a very well-known sentence, my lord, which I remembered, my lord, and this is how the state is to be forced to adhere to the terms which it has laid down in, my lord, in their either in the contract or in the rules or in the regulation, wherever it is. So in this particular case, the state was, my lord, was required to off করে দাও. State was required to adhere to the terms of the letter. Who are the state? I say NBS is the state, having the trappings of the government. KIT, where, my lord, which is owned by the government, that has got the trappings of a state. My lord, Calcutta Municipal Corporation, which is a part of a department of the government of West Bengal, that has got the trappings of a state. Each one of them, and including, my lord, the state of West Bengal, which is bound to follow the rules it has laid down in the contract itself.
But the state did not enter into any contract.
My lord,
State did not enter into
no,
any
the
contract.
state has sanctioned it with the approval of the cabinet. This has been done. My lord, this particular thing, my lord, I was just noticing it. This is not one of those stray contracts. There are 4 parties involved. All, my lord, responsible parties involved in, my lord, in formulation of the contract and then thereafter implementation of the contract.
Apart from you, 3 others.
Yes. My lord, therefore, I submit to your lordship that they are required to follow the rules of procedure. They are required to follow the rules which they themselves have framed. So if you say that I am going to cancel this particular agreement or cancel this particular registered document, then you will have to comply with the provisions of the document itself. You will have to show that this is the breach that you have committed of the clauses of the contract. Therefore, I am terminating. Otherwise, this termination becomes arbitrary and unreasonable. This is the short point, Mara, in all my submissions in this. I am not submitting to your lordship that issue a rule for the purpose of specific performance of a contract. I am not submitting to your lordship that pass a direction so that money can be paid to me. I am not asking for anything. I am saying, look at this conduct of the parties concerned, the respondents concerned. Have they acted reasonably? Have they acted rationally? Now, my lord, I look at it from this point of view. I am a person, I have entered into a contract with my learned friend. He doesn't want me to continue with the contract. What do I expect? First of all, he will send for me that, look, Mr. Mitro, you have not complied with this particular provision. Why shall I not cancel? Give me a hearing. Give a reason as to why you want to cancel the contract, and then cancel the contract if I have committed any breach. But then again, he cannot say that this morning I had indigestion, therefore I don't like you to be the contracting party, therefore I'm cancelling this contract. This they cannot do, which a private party can do, a state cannot. And this is what, my lord, I am submitting to your lordship. Well, this judgment, which I am just handing up to your lordship, this is a judgment of the Supreme Court, three judges bench, Chief Justice Ravanna, Justice Vinith Saran, and Mr. Justice Suryakant. Mr. Suryakant is going to be the Chief Justice now. My lord, here there was a government contract which was sought to be cancelled. And there, my lord, a show cause notice was issued. And my lord, they were called upon as to why the lease deeds which were executed in your favor, should not be cancelled on account of breach of tender conditions. This was the notice issued. And the order was passed by the vice chairman of SIDCO, cancelling the lease. The matter came up before the court. তোমাদের কপি আছে?
So what's the citation?
Well, the citation is 2022 16 Supreme Court cases, page 527. May I, my lord, with your lordship's permission, it is slightly marked.
Yes, sir, you read it.
No, I read it and hand it up to your lordship. Your lordship won't mark my marking it in red. Perhaps it will be easier for your lordship to find out the paragraphs, the relevant paragraph. Para 78. After this discussions have been made on the law, the facts of the case, before we state the conclusion, this court would like to reiterate certain well-established tenets of law pertaining to government contracts. When we speak of government contracts, constitutional factors are also in play. Government bodies, being public authorities, are expected to uphold fairness, equality, and the rule of law, even while dealing with contractual matters. Therefore, my lord, this is in my respectful submission, slightly, my lord, it has, my lord, deviated from what was, my lord, given, what was stated in, my lord, Radhakrishna Agarwala, 77 Supreme Court, which was cited. 1977 to 2016, কত বছর হলো রে? 40 years, my lord. A lot of water has flown down the Ganges. My lord, goes on to say this. It is a settled principle that right to equality under Article 14 avoids arbitrariness. Public authorities have to ensure that no bias, favoritism, or arbitrariness is shown during the bidding process. It was the bidding process. A transparent bidding process is much favored by the court to ensure constitutional requirements are satisfied. Fairness and good faith standard ingrained in the contracts entered into by the public authorities mandates that such public authorities to conduct themselves in a non-arbitrary manner during the performance of their contractual obligations. The constitutional guarantee against arbitrariness, as provided under Article 14, demands the state to act in a fair and reasonable manner unless public interest demands otherwise. However, the degree of compromise of any private legitimate interest must correspond proportionately to the public interest so claimed. Then, my lord, 78. At this juncture, it is pertinent to remember that by merely using grounds of public interest or loss to the treasury, the successor public authority cannot undo the work undertaken by the previous authority. Such a claim must be proven using material facts, evidence, and figures. This is nothing here in this case. Such a claim must be proven using material facts, evidence, and figures. If it were otherwise, then there will remain no sanctity in the words and undertaking of the government. Businessmen will be hesitant to enter government contract or make any investment in furtherance of the same. Such a practice is counterproductive to the economy and the business environment in general. Well, loud and clear. Well, I cannot put it more strongly than this. Well, kindly excuse my underlining this. But I thought that this is what the law says now. In any aspects of in life, if the state government has participated, state government meaning thereby the government, under Article 226, then, my lord, they are to show that they have acted non-arbitrarily, rather reasonably, and, my lord, without any bias towards anybody. Because if any of these elements is not present, then, my lord, the action is liable to be struck down. So this is the next judgment which has been cited. I quickly try and see. Then, my lord, the next judgment which has been cited was 2008 4th Supreme Court cases, page 451. B.K. Muniraju versus State of Karnataka. Well, I don't know why, in what context this was cited, but this is a judgment which has been cited for the purpose of the proposition that to know the real nature of a document, one has to look into the recitals of the document and not the title of the document. I don't know it in what context it has been said, because in so far as I am concerned, I am not relying upon any particular portion of the document. I am relying upon the entire document which has been registered, in respect of which a registered power of attorney has been given to the party, in respect of which, my lord, action has been taken, and in respect of which, my lord, 13 crores has been paid to, more than 13 crores has been paid to NBSTC, and, my lord, more than, my lord, 2 lakhs has been paid on account of grounded to KIT. Well, at the time of, my lord, sanction of the plan, they suddenly backed out. But the reason for backing out, my lord, we do not know.
Sir, according to you, this judgment is not applicable to this case.
Yes. Well, this judgment is not applicable according to me. Well, the next judgment is also, it's slightly, I am confused about this judgment. Reported in 2004, 5 Supreme Court cases, 325. D.D. Sharma versus Union of India. This has been cited for the purpose of showing that the correspondence exchange between the parties are required to be taken.
2004 5 SCC 334.
325. 2004, 5 Supreme Court cases, 325.
You have given a wrong. This is not the copy.
D.D. Sharma versus Union of India. Eta konta?
Parveer Singh.
This is a case under the Arbitration Act. And, my lord, really, this has got no application to the facts of our case. Our case is not an arbitration here. My lord, this, if your lordship looks into the judgment, it is laying down the duties of an arbitrator. And it has been stated that he is to take into account the correspondence for the purpose of construction of the contract. My lord, I could not follow exactly in what context this has been cited. Relevant paragraph is paragraph 24. And there, my lord, I find that this is not really on the points, my lord, on which I had made my submissions. Your lordship will please to see. So the interpretation of
They're
deeds.
trying to emphasize on the refund part.
Refund, I mean, I don't know what refund, my lord. I am not, there's no question of any refund or anything like this in this. Paragraph 24 is, my lord, it is a writ of
It
certiorari.
says the respondent could not hand over the site to the contractor within the stipulated period. The period of contract, however, has extended.
Para
The
22.
appellant contractor made claims for refund of the rebates.
Yes. This has got, I don't know, and kindly come to para 22.
Sir, I have that 3 p.m. matter.
See, your lordship has got. Well, these are 2 or 3 other decisions have been cited by Mr. Mukherjee. Which
So you can conclude on the next date.
I would like to conclude, my lord, because we have been, my lord, trying your lordship's patience for a long period. So, my lord, I think, my lord, time has come when we should put an end to it. When will it be convenient for you? If it is done, my lord, quickly, then, my lord, your lordship will remember exactly what submission. Does your lordship want,
25th?
as your lordship pleases,
25th of November?
25th of November.
Sir.
আজকে হচ্ছে কত?
19th.
19th. 20. Yes, Tuesday. No problem for me.
At 2 p.m. sir.
Assignment. 25th of November.
At 2 p.m.
Yes, sir. 2 p.m. Yes, 2 p.m.
I shall conclude my submission. Does your lordship want me to give a short note?
As you wish.
Dealing with this matter, perhaps it will be easier for you. So many judgments been cited, first by me and thereafter, my lord, by my learned friends on the other side, one after the other. Therefore, perhaps it will be easier for the lordship. I shall make a short note.
Sir, first of all, you conclude
Yes.
on 25th
And then,
and thereafter.
very good. On 25th.